We are on the record in 2024, TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in. And the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that you, if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, maybe I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me getting the paper, those journal entries to the county attorney's office, because I had a few to complete after that day. So they had not all been emailed in. So I think they might still be in the process of being e-filed, because then the following week as I recall correct, I didn't travel to Greenwood County because of all the snow.
Okay.
I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn. Mr. Abel directed to, or advised he should perfect his appeal.
And I'm going to set his pay or appear over 30 days to see if, and remember, you were to pay a $15 or $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry. Can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
No, I didn't, but I was trying to get away.
This case might sound simple on the surface: a traffic violation, a cardboard license plate, and a small fine. But don't blink, because what starts as a routine hearing snowballs into a perfect example of how sovereign-style legal theories collide with real-world courtrooms. Today, you're going to see a defendant who refuses to use a normal license plate, wants a taxpayer-funded appeal, refuses an attorney, then later decides he wants one, but only if the attorney agrees to make arguments that violate their oath to the Constitution. Yeah, that always goes well. We also see a judge who is patient but firm, a defendant who believes the court has it wrong, and two attorneys who both basically say, nope, we are not arguing fantasy law. And just when you think it can't get stranger, we move into the next case, a felony battery on a law enforcement officer, featuring a defendant who immediately decides he doesn't need a lawyer while sitting in a prison jumpsuit. The stakes jump very fast.
I haven't seen anything about a waiver. Mr. Dean, have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send up the appeal notice, and I actually send I requested the what's it called? The report. No, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution. Was the specific statement both the attorneys made to this court.
Yes. So
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
The court still did grant him that an attorney, but the attorney's based. Mr. McClendon became standby because he believed that the arguments were not supported and were in violation of his oath.
This is an important turning point. The judge isn't just being sarcastic. She's pointing out a logical contradiction. Estrada wants to appeal, wants an attorney, and wants to avoid paying the required bond, all while arguing that his homemade cardboard tag was legal. Appeals are not automatic do-overs. They require filing fees, deadlines, paperwork, and in this case, a cash bond to guarantee payment if he loses again. When someone can't pay the basic bond, courts reasonably question how they'll fund a full appellate process. The judge is also signaling something else. This isn't a groundbreaking constitutional case. It's a routine traffic matter that Estrada has turned into an expensive crusade.
It looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
put on his car.
Display it.
That's right. He refused to put it on his car, put on that cardboard.
So despite all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it and you understand. Never mind. All right, but I understand, Mr. Estrada. What is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the verdict.
Okay. And you want to maintain your argument that cardboard tag was legal. The tag that you made was legal.
Yes, that is
Okay,
correct.
all right. I
Correct.
just wanted to make sure I knew what we were doing here. All right, I'll see you back here March 28th at 11 unless you paid your $158 balance. Thank you, sir.
Yeah, I just wanted to know, where do I get the report, the journal entry from Mr. D?
It'll be with the court, clerk of the
The
court.
clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice.
Yeah.
This is State of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in the
man must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point
represent.
of order. What gives you jurisdiction to appoint a lawyer over me?
I have statute.
Right here is where we see the classic gap between YouTube legal theory and real-world court procedure. Estrada is talking about reports, journal entries, and paperwork he believes will overturn everything, but doesn't fully understand how to actually obtain or process them. In court, terminology matters. The journal entry simply documents the ruling. It doesn't magically erase it. The state's attorney also makes it clear the court isn't interested in walking him through appeal steps. Judges cannot act as legal advisors for defendants, especially when the defendant insists on representing himself. When you fire your lawyer, the court doesn't become your new one.
So
Well,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right. Bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point of
all of
order
the
in
points
court
of order that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy
Okay,
of-
then.
I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
This is huge. Two separate attorneys independently said they could not ethically defend Estrada's desired arguments because doing so would violate their oath. That tells us the arguments likely fall into the realm of sovereign citizen pseudolaw. Claims like I don't recognize state authority, I'm traveling not driving, or I can make my own license plate. Lawyers swear to uphold the Constitution and actual law, not YouTube interpretations of them. If your legal strategy requires an attorney to pretend settled law doesn't exist, the problem isn't the attorney, it's the strategy. And when two attorneys both back away, that speaks volumes.
And who is the individual? And sir, what is your name at the jail?
I'm Roman Campbell. I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you. 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have is a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person full life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk, because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not, just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Campbell. I'm a natural person in full life.
He is the heart of the entire case. The judge asked the simplest possible question. Are you really appealing based on the belief that your cardboard license plate was legal? And Estrada answers yes. Not procedure was wrong. Not evidence issues. Just the cardboard tag was valid. This is the hill he wants to die on. Courts don't operate on personal belief. They operate on statutes. Kansas law is crystal clear about what constitutes a legal registration plate, and something you drew at home with a marker does not make the cut. This is the danger of internet law confidence colliding with courtroom reality.
1836 between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp Hill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go. Coming up, your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned, also. So
okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.